Yes, yes.
With respect, may I mention below item 14 and 15 below.
Item 14 and 15.
15 below. The
Yes.
trial court record was not there, my lord, so we requested on the last date, my lord, it has come, my lords. So, my lords, we fix a
Records?
date. Yes, my lords, trial court
Okay,
records. my
okay.
lords.
Yes. So,
So, my lords, we fix a date for the
you
final.
want to go through?
Pardon, my lords?
Would you like to go through?
Yes, my lords. We'll go through
Here,
it.
I have an objection to that. Here, at the time of the hearing of the discharge petition, before the trial court, after the charge sheet was filed,
Okay, this is
all
revision
relevant
against discharge.
Yes, yes, yes.
all
Okay.
relevant documents has been supplied and they have taken, and basing on which the discharge was taken up before the trial court also. At this juncture, arrival of the LCR, otherwise the scanned copy is not the matter to be
No, but it
sought
has
for
to be-
adjournment. It's the matter has been raised for hearing, so I insist that the matter may be heard.
Because
That is
the
my-
trial, there were
No,
two
now
charge
that
sheets.
it has come, we can hear.
Because we can hear, we'll fix a date, we will go through again, my lords, that, my lords. In fact, my lord, there were 19 witnesses, my lords. And I think, my lords, 12 has come, my lords. Recently, he and me, my lords, we both seen, my lords. Rest of the witnesses, they are, my lords, whom,
Short time then? 1 week, after a week?
my lords, I used to come from Delhi, my lords. Can it be, my lords, fixed for the final hearing, my lords, in the first week of June, my lords?
My lord, here I have
June?
an
Yes, my lord.
objection.
Why June?
Lords, Lords, he is coming from, he is posted in Bikaner, Lords. He will come to my office, Lords, in Delhi, Lords. Thereafter we come, Lords. I have matters in Delhi also, Lords. It will be fixed for the final hearing only.
It's fixed for hearing. Today also it's fixed
The
for
order
hearing.
is in your favor, so the matter
Yeah.
may drag on.
Yes, yes, yes. I know this is, let's fix it in the month of April.
Lords,
Sometime in the month of
can
April.
it be, Lords, Lords, I am just giving, Lords, 19th of May, if it can be, Lords.
19th of May.
Yes, my objection may be
Yes,
recorded, my
yes,
lord.
definitely. Heard learned counsel for the respondent. Your name, Mr. Such and such. Stop. Please give your name.
My lords. DK.
Who makes a mention and submits that the trial court records have only come recently and he would like to go through the same. Stop. And accordingly, he prays for listing the matter on, give a date, 19th May 2026 for final hearing. Stop. The prayer is objected to by the learned counsel for the revisionist, Mr. Bandang Wapang, who submits that the matter has been listed for hearing, final hearing, and therefore no further adjournment should be granted as the impugned order is in favor of the respondent. So, having heard both the counsels for the opposing parties, this court is of the view that the matter may be listed on 19 May 2026, on which date no further adjournment will be granted. Okay, let's list accordingly.
Highly pleased.
May I please, my lord?
Yes,
Lordship, I beg to mention item 11.
11.
11, your lordship, on behalf of my colleague KV, your lordship. Lordship, if this matter can be listed after 4 weeks, your lordship, he is in bereavement, my lord.
K. Angami.
Yes, my lord.
Heard learned counsel, Mr. N. Angami, who makes a mention on behalf of Mr. K. Angami, learned government advocate appearing in this matter, who is in bereavement, and prays for listing the matter after 4 weeks. Stop. List after 4 weeks as prayed for. Learned counsel, Mr. M. Kongyakna, is present for the petition. Yes, list after 4 weeks.
I'm obliged, my lord. May I please, lordship? My lord, I beg to mention item number 20. My lord, here affidavit is ready and I've sent for waiting. So kindly allow me 1 week time to file affidavit, my lord.
This supplementary list is for mediation, is for
Yes.
referral to mediation. So you only have to get the instructions first, whether the respondent wishes to refer it for mediation or not. I have not gone through the file. I don't know what the matter is. What is it? Landowner?
Yes, my lord. Land compensation.
Land compensation?
Yeah, please,
Yes,
Your Lordship.
yes.
I'm appearing on behalf of my senior, Gauhati, Learned CGC. Lordship, in this matter, the respondent 1 to 4 are not ready for,
Not willing.
not willing for mediation.
Okay then. Learned, item 20, na?
Lordship.
Learned counsels for the parties submits that they are not ready to refer the case for mediation. Stop. Accordingly, the learned government advocate, Mr. Tipa Pom, submits that he may be given
1 week time to
1
file
week
affidavit.
time to file affidavit in opposition. Stop. List after 1 week. Yes.
Similar prayer for item number 21, my lord.
1 week.
Yes, and item number 22.
This
I'm
one
yet-
is also compensation.
Yes, my lord. And
okay.
item
Same-
number,
same order.
Item number 22 here, I have not received any instruction, my lord. So kindly allow me 3 weeks time. That is.
In item 22, you say 3 weeks, okay? 3 weeks in order to file affidavit by the state respondents. Yes.
Much obliged.
Lordship.
May it please your ladyship.
Yes.
Your ladyship, may I mention item number 3? Your ladyship, this is a fixed item, however, the principal council is indisposed today. If this matter may kindly come up on 23rd, that is next Monday.
You're mentioning on behalf of
On behalf of Lima.
Lima Tushi.
Yes.
Okay. Learned counsel, Mr. James Newma, appearing for the respondents, submits that the leading counsel, Mr. Lima Tushi, is indisposed and accordingly prays for listing the matter on 23 this month.
Yes, Your Lordship.
23/3/2026. So learned counsel for the petition appellant is present and has no objection. List on 23/3 is prayed for. Yes.
Much obliged.
Item number 4. And I'm representing respondent number 3. So I'm yet to file my objection, so your lordship may kindly grant me some more time to file the objection.
How much time?
3 weeks time.
3 weeks. For R3. R3.
Yes.
Learned counsel, Mr. Sergeant. Any objection?
No.
Mr. Sergeant Such appearing for respondent number 3, prays for listing the matter after 3 weeks as he would like to file an affidavit in opposition. Stop. Learned counsel for the petitioner, Mr. Lima Wapang, is present and has no objections. List after 3 weeks. Yes.
Lordship, interim is allowed to continue.
The interim order passed earlier shall continue till the next date. Yes.
May I please, my lord? Lordship, item number 2. Lordship, on behalf of KV, I'm informed that your lordship, the petitioners are supposed to implead the new PNR secretary and the engineer in chief, my lord.
Okay.
Lordship, in that case, Lordship, I'm given 4 weeks time to defend his directives.
Learned counsel, Mr. Lima Wapang, appearing for the petitioner, submits that he would like to file an IA to implement the new incumbents who have been posted in place of respondent number
2 and 3.
2 and 3. So prayers allowed list after 4 weeks. Yes.
Obliged, my lord. Your lordship, item number 24 and 25, your lordship. In this matter, your lordship, verbally I have been informed that the file has been pushed up to the authorities for consideration. However, I have not yet received any instruction to that effect. So if 3 weeks time can kindly be granted, your lordship.
What is the matter about?
The matter, your lordship, is about pending bills, my lord.
Pending bills?
Yes, my lord.
In that case, it can be settled in the mediation.
Yes, but your lordship, the government is yet to take a call whether they are willing to go for conciliations or not, your lordship.
No,
So if-
because if they are willing to pay,
Yes, yes.
then it can be settled.
Yes, yes, correct, your lordship. So if 3 weeks time can kindly be granted so that I would
Okay,
receive
okay.
the, yeah.
Learned counsel 24 and 25. Okay. Learned government advocate, senior government advocate, Mr. N. Nangami, submits that the matter is under consideration of the government and therefore he would like 3 weeks time to
Lordship.
receive further instructions. So list after 3 weeks. Okay. Learned counsel for the petitioners, Ms. Sergeant Sir is present.
Lordship, I also beg to mention item 27. Lordship, in this matter, I have not received any instruction with regards to conciliation. However, your lordship, the similar matters is pending before the division bench, that is the writ appeal 6 and 7, your lordship. So the decision taken in writ appeal 6 and 7 will decide this particular case, your lordship.
Okay.
So if
Is
this
that-
matter, and your lordship, the petitioner herein is a private respondent in the writ appeal 6 and 7, your lordship. So I am sure they will agree with me
Then in that case, we can list this matter after disposal of the writ appeals.
Maybe if it can be listed after 3 or 4 weeks then.
Okay. List the matter after 3 weeks on the prayer of the learned counsel for the parties. Yes, we'll just say that. 3 weeks.
I am deeply obliged.
Will be allowed to make a mention of item number 26, my lady. My lady, here my clients are not willing to go for mediation.
Okay, okay.
So this can come up after 3 weeks, my lady.
This is regarding that renaming railway
Yes,
station.
yes, my lady. Since it's a sensitive
Yes,
issue,
yes, yes. The 26, okay, the learned counsel for the parties submit that they are not willing to refer the case for mediation and accordingly list after 3 weeks. After 3 weeks. Pleadings complete?
no. State as well as the union is also.
Okay, 3 weeks. In the meantime, you do the needful. List after 3 weeks. Yes.
Interim can
The,
be.
the interim order passed earlier shall continue till the next date. Yes.
May I please, Your Lordship? Lordship, I beg to mention item 6, Lordship.
6.
Here, I'm for the sole respondent, Lordship. I may allow a week's time to file my affidavit, Lordship.
1 week.
A week's time.
Compliance, that means compliance.
Compliance affidavit.
Learned counsel, Mr. V. Momi, appearing for the respondent, prays for 1 week's time to file affidavit. So praise allowed. Learned counsel, Ms. Such and Such is present for the petitioners. Yes, list after 1 week.
Obliged.
May I please, Your Lordship,
Yes.
I beg to mention item number 16, Your Lordship.
Item
16.
16.
Yes. Here the petitioner is not ready for mediations.
Item 16, the learned counsel for the petitioner, Ms. Kim Penyu, submits that the petitioner is not willing to refer the case for mediation and accordingly prays for listing the matter after 2 weeks, after 3 weeks. List after 3 weeks. Learned counsel, Mr. James Newma is present for respondent number
Private respondent.
4.
4.
Respondent number 4. Yes. 3 weeks.
My lady. My lady, I'm attending to GC, my lady. My lady, I beg to mention orders item number 28, my lady.
28.
28, yes.
Yes.
The parties herein are not interested to settle the matter through amicable settlement. So it will be.
Learned counsel, Mr. V. Devnath, appearing for the appellants, submits that the parties are not willing to refer the case for mediation. Accordingly, list the matter after 3 weeks. Okay.
Much obliged.
Yes.
May I please, Your Lordship, I beg to mention item number 13 on behalf of my senior, Takakichu. Can you fix this date on 30 as he's out of station?
Item 13. Learned counsel, Ms. Such and Such, makes a mention on behalf of the leading counsel, Mr. Takakichu, to list the matter after
30.
on 13th. Okay, on 13/3, as the counsel is out of station. So, learned counsel, Mr. M.T. Wapang is present for the respondent and has 1 to 4 and has no objections. List on 13/3. Yes. 13/4. What did you say? 30. 30. Okay. 33. Yes.
Your Lordship, I beg to mention item number 23. Here, Your Lordship, the state respondents would rather prefer the matter to be settled to regular court proceedings, Your Lordship, rather than mediation.
Item
23.
23. Okay. You don't want it to be settled. Okay. Learned Government Advocate Ms. A. Ayame submits that the state respondents are not willing to refer the case for mediation and would like the matter to be adjudicated by the court. So accordingly, list the matter when? After 2
Your
weeks.
Lordship, they are yet to file their reply.
Okay,
The last
okay,
occasion they have
okay.
filed.
After 2 weeks. Then. Yes, list after 2 weeks.
Much congratulations.
Please, Your Ladyship. Ladyship, I beg to mention item 5. Here I'm appearing for respondents 5 and 6. We are ready with the affidavit. However, we're yet to obtain the signatures. So if 2 weeks can be granted. For respondents 5 and 6.
My Lord, I have no objection to that.
If it's a compliance affidavit, then
My Lord, their election
department,
Huh.
5 and 6.
Okay.
1 to 4 is state.
Huh.
7 to 9 also is state.
Hmm.
Last time, Accountant General took 2 weeks time. So as far as 5 and 6 in 10, they are doing something for which seeking time I have no objection. The government
But
side
the
also
state
must-
respondents,
Yes.
who's appearing for the other respondents, 1 to 4?
Lordship, I am for respondent number 1, my lord.
Your Lordship, I'm for respondent 3, 4, 7, 8, and 9.
I'm for the respondent number 10, Lordship.
So, compliance, what are the steps taken?
Your Lordship, on previous occasion, I have submitted a letter from the department stating that they have submitted all the files to the PNR, to the Accountant General's office. That was the
Okay,
last-
okay.
There is a communication from the Accountant General.
Okay, let them appear then. Who is appearing today for the account? You are appearing?
Lordship,
Okay.
yes. Lordship, according to the pair letter dated 17/9/2025, in para 6, may I read it, Lordship? As per decision of the Accountant General, Nagaland dated 1/7/2011, this office is to take approval of the PNR department for any pension case received in delay for 5 years and more, Lordship. As such, the instinct claim for extraordinary pension case made after a gap of approximately 35 years by Alem Lachang requires approval from PNR department, Lordship. So we are waiting for
In that
instruction.
case, you're blaming each other. Now again, who's appearing for PNR?
Your Lordship,
You sort it out, okay. We'll give you 2 weeks time. Learned Counsel for the petitioner, Mr. Imti Longchar is present. So Learned Counsel, Mr. Znongus appearing for respondent number 5 and 6, prays for 2 weeks time to file his affidavit. Stop. Learned Counsel, Mr. N. Angkami appears for respondent number such and such, Miss A.M.E. for respondent number such and such. Just take their respondent numbers, okay? And then Mr. such and such for respondent number 10. Respondent number 10. Stop.
Respondent number 2. My lord, it appears that my learned friend, they are not representing. Respondent number 2.
Oh, 2 is the
which is here,
PNR.
yes.
PNR. Oh, the 2 is the main respondent actually.
Yes, now, yes.
Notice is complete.
My lord,
Notice.
if need be, I'll take a trustee service also.
You do
for
that.
matter.
Stop.
Yes.
Respondent
I
number
may be
2.
given-
Respondent number 2 is not represented today. The learned counsel for the petitioner is allowed to take steps on respondent number 2, fresh steps on respondent number 2 by Dusty, and thereafter file compliance affidavit.
My lord.
List after 2 weeks, okay?
My lord,
List after 2 weeks. Yes.
much obliged.
Obliged.
May I please your Lordship. Lordship, I beg to mention item 17. The state wish to pursue this matter before this honorable court and not refer for mediation.
Okay. Number 17, Learned Government Advocate Mr. M. Longcomer submits that the state respondents are not willing to refer the case for mediation. Accordingly, list the same after 2 weeks. After 2 weeks.
And similar prayer for item,
Lordship, there is an interim in item 17.
Okay, the interim order passed earlier shall continue till the next date. Then item
similar for 18 and 19.
18, 19 also, same order, okay. But no interim in 17 and
18 and 19.
no, wait. Just now you mentioned 18 and 19.
Yes.
Yes. In 17, there is interim order.
Yes.
In 18 and 19, there is no interim order, but list after 2 weeks. Yes.
Lordship.
And get the name of the petitioner's counsels also. Yes, after 2 weeks.
Lordship, I'm appearing on for item number 19. I'm appearing on for the petitioner.
In which 19?
Yes.
Okay. That's why you give your name. Yes.
Lordship, Lordship.
Okay. Yes, call.
item number 1.
Is in non-compliance with the court
Yes,
order.
which is the order? WP 191.
WPC 191 of 2025.
Considered this. There are two orders, 25.
One order, Lordship.
25-9, 25-9.
25/9/2025
Yes.
in WBC 191 of 2025.
And when did you communicate the order to the respondents?
Lordship, we have served the copy to the respondents on date 24/10/2025. I have annex as annex 01,
24.
annex A. Page number 8, Lordship.
Page number 18.
8,
Oh,
Lordship.
Page number 8. (24:10). Okay. The instant application under Section 12 of the Contempt of Courts Act, read with Article 215 of the Constitution of India, has been filed by the petitioner alleging willful and deliberate violation of this court's order dated 25/9/2025, passed in WPC 191 of 2025. Stop. Learned counsel for the petitioner, Mr. Such and such. Stop. It is the contention of the petitioner that this court-wide order dated 25/9/2025 in WPC 191 of 2025 had directed the respondents to consider the case of the petitioner for regularization in terms of the scheme notified in the office memorandum dated 17/3/2015, and to bring the process to its logical conclusion as expeditiously as possible, preferably on or before 31/1/2026. Stop. It is further stated that the copy of the order dated 25/9/2025 had been served on the respondents on 24/10/2025. Stop. However, till date, the respondents have not complied with the direction of this court. Stop. Hence, the present application has been filed. Stop. Issue notice returnable in 4 weeks. Stop. The petitioner shall take steps for service on the respondents 1 to 5 by speed post as well as usual process within 3 working days, list after 4 weeks.
Much obliged.
For orders, item number 7.
This is also contempt.
Please, Your Lordship.
Yes.
Your Lordship, I'm appearing on behalf of my senior. We have taken steps upon respondent number 7 through registered post ID.
Have you, this is, you had filed for amendment of the course title, isn't it? You
Yes,
have amended, you have put in the amended course
Yes.
title?
Yes, we recommend.
Okay, and then, who were the newly implemented respondents? Six and seven?
Lordship, 5, 6, and 7.
5, 6, and 7.
Yes, 5 is the new chief engineer. 6 is the commissioner secretary to PNR department, and 7 is the secretary. Yes.
Yeah, okay. Third learned counsel for the petitioner, Mr. Such and such. The course title has been amended as allowed in IA Civil 20 of 2026, and the newly implemented respondents number 5, 6, 7 have been included in the have been arrayed as respondents in the course title, in the newly amended course title. Stop. The learned counsel for the petitioner also submits that he has taken steps he has taken steps for notice on the respondents number 5, 6, and 7. When did you take steps? Okay. Has taken steps on 5, 6, and 7. Stop. The office note dated 11/3/2026 indicates that the notice has been sent by speed post dated 26/2/2026, and the return service report is still awaited. Stop. Accordingly, list the matter after 3 weeks.
Oblige, my lord.
Item number 8. Item number 8.
None appears for the appellant when the matter is called. Learned Public Prosecutor, Mr. Who is appearing? Mr. Tipapom is present. Stop. The return service report on respondent 2 is still awaited.
My lord, here
Yes.
petitioner counsel is in bereavement. So let the
Okay,
matter be listed after.
Anyway, the
3 weeks, my lord.
R2 service report is still awaited. also.
Okay.
Yes. Is this POXO? If it's POXO, then the steps have to be taken through the PP, no? So you have to intimate the court as to whether it has been served from. Learned Counsel, Mr. PP, Learned PP, Mr. Tipapom submits that the counsel for the appellant is in bereavement. Stop. However, since this is a POXO matter, the Learned PP is required to ascertain the service of notice on the respondent number 2 through the concerned police station. Stop. Accordingly, list after 3 weeks, on which date the Learned Public Prosecutor shall also apprise the court regarding the notice on respondent number 2.
Much obliged.
For orders, item number 9.
Please, Your Lordship.
Yes.
Your Lordship, as per the Honorable Court Order dated 5/3/2026, step has been taken upon respondent 3 and 4.
Yes. Learned Counsel for the petitioner, Miss Mary.
Yes, Your Lordship.
Mary and Sue is present. The office note dated 11/3/2026 indicates that notice upon respondent number 3 and 4, is it? 3 and 4 has been taken through speed post on 9/3/2026, and return service reports are awaited. Stop. Learned Counsel, Mr. N. Angami appears for respondent number
1 and 5.
1 and 5, and is
2,
such
3,
and
4.
such for respondent number 2, 3, and 4. 2, 3, and 4?
4.
3 and 4,
4, Your
only recently notice has been taken. Yes. So, 2, I think. 2, respondent number 2. Stop. List after 3 weeks, awaiting return of service report on respondent number 3 and 4. Yes.
For hearing, item number 10.
This is not for hearing.
Orders.
This is for orders.
For orders.
Ms. Chung. Notice on R4. Learned Counsel for the petitioner, Mr. A. Sophie is present. Stop. The notice upon respondent number 4 has been sent by speed post as well as usual process, via letter dated 16/12/2025, and the office note dated 17/12/2025 indicates that the return service report is still awaited. The government is also a party, isn't it?
Yes, my lord.
The government advocates have all disappeared. None appears for the respondents number 1, 2, and 3 when the matter is called. List after 3 weeks, awaiting.
My lord, if this
You want to
can
take
allow me
first
Dusty-
steps?
Dusty.
Dusty, okay. Learned counsel for the petitioner prays that he may be allowed to take steps by Dusty. Dusty mode. Stop the. The prayer is allowed. The petitioner shall take steps for service on the respondent number 4 by Dusty and thereafter file compliance affidavit. List after 3 weeks.
My lord, there is an interim.
Yes, yes. The interim order passed earlier shall continue till the next date. List after 3 weeks.
Bless, my lord.
For hearing, item number 12.
Yes.
Lordship, this make appeal is filed against the award and judgment passed by the learned MSCT Tribunal, Mokokchung, Nagaland, dated 23/09/2021, Lordship. Lordship, the brief fact of the case is that on 053/17, the claimant was riding as a pillion rider on the motorbike number AS07E 2030 Hero Honda, driven by the opposite party, Shri Gopi Kisan Rati, who is the owner of the offending vehicle and also the brother of the claimant, Lordship. He has also been implemented as the opposite party in the MAC appeal number 20 of 2018, Lordship. Well, the claimant was going to the Bishwanath rally on the way at Bihali Tinali. Due to construction of 4 lane, the road condition of the Bihali area was very deplorable and the road was affected with numerous potholes, also speed breakers. The motorbike was driving in a high speed and in a reckless manner. Due to rush and driving, suddenly the motorbike jumped over a high speed breaker and overturned on the road, Your Lordship, as a result of which both the occupants sustained injuries. And the claimant responded filed an MSCT Tribunal case number 20 of 2018 at Mokokchung, where the learned tribunal passed an award and judgment dated on 3/9/2021, awarding an amount of rupees 64,97,880 along with the interest at 9% per annum. May I please, Your Lordship? Before I go to the ground of my MAC appeal, I would like to highlight important facts of the case, Your Lordship. If Your Lordship may kindly come to page 4.
Page 4 of your petition.
MAC appeal, page 4 of my MAC appeal. That the appellant had received the summon from the Honorable Tribunal on 10/7/2018 and 21/8/2018. Accordingly, the Council for the Insurance enter appearance by way of filing written statement cum objection and application under Section 170 AB of the MV Act 1988. However, the Honorable Tribunal did not admit the said application. Lordship, the written statement cum objection filed by the appellant is in page 20. Page 20, type copies in page number 24, Your Lordship.
Okay, then what happened? It was not allowed.
Yes, Your Lordship. As in page number 40, Your Lordship, page number 40 of the judgment being passed by the Learned Tribunal Court in page number 40 in the last para. On two occasions, notice issued against the Divisional Manager, Oriental Insurance Co. Ltd. Dimapur. Firstly, notice posted through the registered postal receipt number so-and-so, dated 097-2018, and secondly, notice posted through the registered postal receipt number so-and-so, dated 16/8/18. Both the notice issued through the registered post duly served against the Divisional Manager, Oriental Insurance Co. Ltd. However, the Divisional Manager chose not to appear or contest to the claim, Your Lordship. It has been reflected clearly that we have not appeared, whereas we have filed our written statement, Your Lordship. Coming to the main ground in page number 5, page 5 of my make appeal, Your Lordship.
Yes.
For that, the learned tribunal has prima facie committed error and illegality in passing the final award without taking into consideration the basic requirement of Motor Vehicle Act 1988. For that, the learned tribunal has erred in law while passing the said impugned judgment and order dated 23/9/2021, as the appellant was not made an efficient party or a pro forma party in the claim petition, but has awarded against them. As such, the said impugned judgment and order dated 23/9/2021, being bad in law, is liable to be quashed and set aside. If Lordship may kindly come to page number 39. Lordship, here we were not made parties. We were not made effective party or a pro forma party, Your Lordship, in the MAC appeal, Your Lordship. Coming to my next round, for that, the learned tribunal has erred in law for not admitting the written statement cum objection and an application under section 170A(b) of the MV Act 1988 filed by the appellant company. The said impugned judgment and order dated 23/9/2021 has brought miscarriage of justice, and as such is liable to be quashed and set aside. For that, the learned tribunal has passed the said impugned judgment and order dated 23/9/2021 without considering the facts that the injured was a businessman and that due to the injury and disability, the claimant did not suffer any loss of income. His business is still in continuity. Disability itself does not entitle a claimant for loss of earning. As such, the impugned judgment order dated 29/9/21 is liable to be quashed and set aside by this honorable court. For that, the learned tribunal has taken an erroneous view of the whole matter and arrived at a misplaced conclusion in holding that the claimant has suffered permanent disability without adducing evidence of the doctor. As such, the impugned judgment and order dated 23/9/2021, being bad in law, is liable to be quashed and set aside, Your Lordship. Supplementary to my ground in number E and F, Your Lordship, if I may cite some case laws, Your Lordship. SCC 2011-1-343. Ajay Raj Kumar versus Ajay Kumar and another, Your Lordship.
Yes.
Para number 10, if I may read, Your Lordship. Where the claimant suffer a permanent disability as a result of injuries, the assessment of compensation under the head of loss of future earning would depend upon the effect and impact of such permanent disability on his earning capacity. The tribunal should not mechanically apply the percentage of permanent disability as the percentage of economic loss and loss of earning capacity, in most of the cases, the percentage of economic loss, that is, the percentage of loss of earning capacity arising from a permanent disability, will be different from the percentage of permanent disability. Some tribunals wrongly assume that in all cases, a particular percentage of permanent disability would result in a corresponding loss of earning capacity, and consequently, if the evidence produced show 45% as the permanent disability, will hold that there is 45 loss of future earning capacity. In most of the cases, equating the extent percentage of loss of earning capacity to the extent percentage of permanent disability will result in award of either too low or too high a compensation. Paragraph 11, Your Lordship. What requires to be assessed by the tribunal is the effect of the permanent disability on the earning capacity of the injured, and after assessing the loss of earning capacity in terms of a percentage of the income, it has to be qualified in terms of money to arrive at a future loss of earning by applying the standard multiply method used to determine loss of dependency. We may, however, note that in some cases, appreciation of evidence as assessment, the tribunal may find that the percentage of loss of earning capacity as a result of the permanent disability is approximately the same as the percentage of permanent disability, in which case, of course, the tribunal will adopt the said percentage for determination of compensation. Your Lordship, para 12. Therefore, the tribunal has to first decide whether there is any permanent disability. If so, the extent of such permanent disability. This means that the tribunal should consider and decide with reference to the evidence whether the disablement is permanent or temporary. If the disablement is permanent, whether it's permanent total disablement or permanent partial disablement. If the disablement percentage is expressed with reference to any specific limb, then the effect of such disablement of the limb on the functioning of the entire body, that is the permanent disability suffered by the person. If the tribunal concludes that there is no permanent disability, then there is no question of proceeding further and determining the loss of future earning capacity. But if the tribunal concludes that there is permanent disability, then it will proceed to ascertain its extent. After the tribunal ascertains the actual extent of permanent disability of the claimant based on the medical evidence, it has to be determined whether such permanent disability has affected or will affect his earning capacity, Your Lordship. Your Lordship, also in GLT 2010-176. Para 10, Your Lordship. The learned counsel for the appellant pointed out that the learned tribunal relied on the disabled certificate to conclude the claimant permanent disability of 55% without examining the doctor who had evaluated and issued the certificate of disability to the claimant. Learned counsel further contended that the certificate purported to be issued by the medical board of Champion Board, the signature of the doctors working in civil hospital ISO. Para 11, as a matter of fact, in assessment of the percentage of disability of an injured, a medical expert in the field plays a crucial role. On the basis of such assessment, a tribunal embarks on evaluating the loss of earning capacity triggered by disability of the claimant. The degree of disability and loss of earning capacity are not synonymous. Loss of earning capacity cannot be assessed by resorting to mere guesswork. The tribunal should, for all practical purposes, take existence of a qualified medical practitioner to assess the extent of permanent disability of the claimant. On the other hand, non-examination of the doctor as a witness who gave the certificate would deprive the insurance company test the veracity and of the truthfulness of the statement and correctness of the documents placed on the record by the claimant before the tribunal is required to assess the loss of earning capacity, keeping in view the percentage of the disability suffered by the claimant. Therefore, the assessment and evaluation of the injury of the claimant is of paramount significance in proper adjudication of the claim petition. In support to that, Your Lordship, if Your Lordship may, GLT 2001-1, page 393. National Insurance Co. Ltd. versus Chandreswar Thakur and others, Your Lordship. Para 2, Your Lordship. The whole contention of the appellant is that the learned tribunal arrived at conclusion that the claimant suffered permanent disability without examining the doctor. Since the claimant sustained injury, it was incumbent on the part of the claimant to have examined the doctor and established its case as to what percentage of permanent disability was suffered by the claimant. It would clearly appear that besides submitting a certificate from the doctor, no doctor who has been treated by the claimant have been examined by the claimant. No non-examination of the doctor to establish the extent of disability suffered by the claimant deny the opportunity of the insurance to cross-examine the doctor. In our jurisprudence, witness put up by either of the parties is subject to cross-examination so as to test veracity or the truthfulness or correctness of the statement of the witnesses. In the instant case, no doctor has been examined to establish the extent of disability suffered by the claimant, and in that view, the permanent disability has not been proved, and apart from the tribunal settle the liability with the insurance on the compensation assessed on the basis of permanent disability suffered by the claimant without giving any opportunity of cross-examining the doctor. Coming back to my MAG appeal, Your Lordship, page 7, Your Lordship. For that, the learned tribunal has passed the
Page 7.
Yes, Your Lordship. Has H, Your Lordship. For that, the learned tribunal has passed the said impugned judgment and order dated 23/9/2021 without considering the facts that there is no evidence to show that any future medical expenditure will be required, but the learned court has granted rupees 2 lakhs for future medical expenditure. As such, the said impugned judgment and order dated 23/9/2021 is liable to the question set aside. Your Lordship, for that, the learned tribunal has passed the said impugned judgment and order dated 23/1/2021 mechanically and without application of judicious mind in holding the appellant liable to pay the final award of 64,97,880, Your Lordship. If I may, Your Lordship, in the previous occasion, I have prayed to this honorable court to file an additional affidavit because in the ground of the MAG appeal, we have left out some important grounds, that is the jurisdiction, Your Lordship. But this honorable court has allowed us to make an oral submission during the time of hearing, Your Lordship. If Your Lordship may kindly come to page number 20. And type copy will be in page number 24, Your Lordship. Your Lordship, in our written objections and our written statement and come objection in para number 1, we have raised objection regarding the jurisdiction, Your Lordship. And the accident took place at Assam, and all the documents submitted by the claimant to the learned tribunal court was all from Assam. Your Lordship, the claimant, since all the evidence and document was all in Assam, they have not filed in Assam and they have filed it in Mokochung, Your Lordship. The tribunal at the Mokochung should should not have entertained the claim petition, and they should have transferred it to Lakhimpur, Assam, since the accident happened in Assam and not Mokochung, and also the claimant was not residing in Mokochung, Nagaland, Your Lordship. Thus, Your Lordship, in the absence of such evidence, the present claim being filed under Section 166 of the MV Act is a violation of grounds of jurisdiction, Your Lordship. And also, Your Lordship, the interest rate which have been passed by the tribunal at 9% per annum is on the higher side, Your Lordship. As in the case of Sharla Verma and others versus Delhi Transport Corporation, in another reported in 2009, 6X SCC 121 has laid down the principle to calculate the compensation and rate of interest at the rate of 6% per annum, but the learner tribunal has violated that principle, Your Lordship. So, Lordship, it is my humble submission to set aside the judgment dated 23/9/2021 passed by the MSCT Tribunal Mokochung, Your Lordship.
Acha, why the tribunal did not allow this, the written statement? Any more?
No.
May it please your Lordship? I have prepared a gist of written argument. May I forward it, Lordship?
Okay, but first of all,
Yes.
they said that they had filed the written statement, but it was not
No,
allowed.
Lordship.
It was not
It is
admitted.
incorrect, Lordship. That is absolutely incorrect, Lordship. Their ground number 4 allegation is that written statement and petition under section 170A(b) of the MB Act is not admitted by the tribunal. That is their allegation. The allegation is entirely false and perverse. Despite service of notice, the appellant never appeared or engaged any counsel before the tribunal because of their lethargy, inaction, and dereliction of duties. It is if the appellant filed WS and the petition under section 170 of the Act before the tribunal, and if it is not admitted by the tribunal, there might be such order of the tribunal by showing the reason thereof. Nothing order has been passed by the trial court that they have approached the tribunal for filing of written statement or any other connected petition. That is not their Lordship. Even assuming that not admitted, Lordship, if the appellant was tried to file their WS and other petition before the tribunal, and if it is not admitted by the member, what steps has been taken by the appellant against such rejection? Nothing. Only to hush up their lethargy and inaction, also dereliction of duties, the appellant is giving false statement to save their skin, Lordship. That is the fact, Lordship. Lordship, this petition is filed under section 149 subsection 2, presently the section 150 subsection 2 of the MB Act, wherein the insurance company is not required to be implied as a respondent, and they were only noticee in this case.
Okay.
Lordship. It is a, yes, Lordship. In the claim petition, Lordship, about maintainability of appeal, question of maintainability of the appeal, Lordship.
Notice under section 149.
149 subsection 2 and now presently section 150 subsection 2. Lordship, the claim petition filed before the member motor accident MSCT Mukoksung, the appellant insurer is implied only as a noticee as required by section 149 subsection 2 after amendment section 150 subsection 2 of the Motor Vehicle Act. And as such, unless by a reason order passed by the tribunal as required by section 170 of the MV Act, by satisfying with the two condition precedents, allowed the insurer to implement as a party to the proceeding, no insurer can contest or raise the ground other than defense within the meaning of section 149 subsection 2 of the MV Act. Their grounds are limited, Lordship. They cannot, appellant cannot raise any other ground beyond the provision of section 149 subsection 2, Lordship. In the instant case, no such prayer has been made by the insurer before the tribunal for allowing the appellant to contest the claim on all or any of the grounds that are available to the person against whom the claim has been made, nor even the insurer appellant have filed any petition before this honorable court along with the memorandum of appeal for allowing the appellant to file the appeal on available grounds, Lordship. Lordship, there is no bar at all to file a multiple petition can also be filed under section 170 of the Motor Vehicle Act at any stage, whenever it is appeared that there is any collusion. Lordship, even before this honorable court, no petition filed under section 170 of the Motor Vehicle Act to allowing them to contest the case on merit, Lordship.
If they did not appear, then...
Lordship, the Act does not require the claimant to implement the insurer as a party respondent. For satisfaction of this honorable court, the respondent claimant relied upon the following decision of our apex court: United India Insurance Company versus Siladatto, 2011 10 SCC 509. In para 13, Lordship, the scheme of the Motor Vehicle Act 1988 as contained in chapter 11, insurance of motor vehicle accident third party risks, and 12, claim tribunal proceed on the basis that an insurer need not to implement as a party to the claim proceedings, and it should only be issued as a statutory notice under section 149 subsection 2 of the Act, so that it can be made liable to pay the compensation awarded by the tribunal and also resist the claim on or any of the grounds mentioned in clause A and B of subsection 2 of section 149, subsection 1, 2 and 7 of the section 149 clearly refers to the insurer being merely a noticee and not a party. Similarly, section 158.6, 166.4, 168.1 and 170 clearly provides and contemplates the insurer being merely a noticee for the purpose mentioned in the Act, not being a party to the claim proceedings, Lordship. Their allegation is that they have not implemented as a respondent into the claim. But actually, law does not allow to implement them as a respondent into the claim petition. Lordship.
But even then notice was sent?
Notice sent, Lordship. On two occasions, I shall come to the point after sometimes, the para 14, Lordship. When insurer is implemented as a party respondent to the claim petition, as contrasted from merely being a noticee under section 149.2 of the Act, its rights are significantly different. If the insurer is only a noticee, it can only raise such of those grounds as are permissible in the law under section 149 subsection 2. But if he is a party respondent, it can raise not only those grounds which are available under section 149 subsection 2, but also all other grounds that are available to a person against whom a claim is made. It therefore follows that if a claimant implements the insurer as a party respondent for whatever reason, then as such, respondent the insurer will be entitled to urge all contentions and grounds which may be available to it. Lordship, para 15 of the judgment. The Act does not require the claimant to implement the insurer as a party respondent, but if the claimant chooses to implement the insurer as a party, not being a noticee under section 149.2, the insurer can urge all grounds and not necessarily the limited grounds mentioned in section 149 subsection 2 of the Act. If the insurer is already a respondent, having been implemented as a party respondent, it need not ask the permission of the tribunal under Section 170 of the Act to raise grounds other than those mentioned in Section 149, subsection 2 of the Act. Under the principle, the instant appeal is liable to be dismissed with compensatory cost as the appellant, without any valid reason, by filing this appeal, putting the claimant in a distressed condition, Lordship. The appeal filed by the insurer is also not maintainable at all in the eye of law, Lordship. Despite duly service of notice on several occasions, the insurer remained absent before the tribunal nor engaged any counsel to represent the insurer, and as such, ex parte proceeding allowed against the insurer. As appeared, the appellant insurer is not aggrieved with the judgment and award passed by the tribunal. Otherwise, before filing of the appeal, the appellant could have filed a petition under Order 49, Rule 13, CPC before the tribunal for setting aside of the order. Lordship, if a order passed ex parte, if the appellant is aggrieved by that order, first step, they have to file a petition before the tribunal under Order 9, Rule 13, CPC. That has not been done, but straight away they have come here to file appeal before your Lordship. Lordship, regarding service of notice, in para 3 of my, page 3 of my gist of argument, Lordship, as appeared in the judgment and award dated 23/9/21, the learned member issued the following notice against the appellant insurer under Section 149, subsection 2 of the Motor Vehicle Act. Number 1, notice against the Divisional Manager, Oriental Insurance Company Limited. Firstly, notice posted through registered postal receipt number so-and-so dated so-and-so. And secondly, notice posted through the registered post receipt number so-and-so dated 16/8/18. Both the notice issued through the registered post are duly served against the Divisional Manager, Oriental Insurance Company Limited. However, the Divisional Manager does not
choose not to appear.
Yes, choose not to appear in the tribunal. To prove the service report, a copy of the certificate issued by the Sub-Postmaster, Circular Road, Sub-Post Office, Dimapur, Nagaland, dated 30/11/2018 is filed in the court record. The contents of the certificate is reproduced as herein below, Lordship. Certified that registered post letter number so-and-so dated 9/7/18 duly delivered on 10/7/18 and registered post letter receipt number so-and-so dated 16/8/18 duly delivered on 21/8/18 to the Divisional Manager, Oriental Insurance Company Limited, Divisional Office, Dimapur, Nagaland, which has been duly acknowledged and received by the Divisional Office by putting their signature and official seal. Copies of the acknowledgement and delivery sheet dated 10/7/18 and 21/18 are annexed herein. That is the clear service report of the postmaster of the Dimapur office. Secondly, Lordship, against the notice against the branch manager, Oriental Insurance Company Limited, Badati Road, PO, Bihuria District, Lakhimpur, Assam, PIN number so-and-so. Firstly, notice issued through the registered postal receipt number so-and-so dated 9/7/18, and secondly, notice posted through the registered postal receipt number so-and-so dated 16/8/18. To prove the service of notice, a certificate obtained from the Sub-Postmaster, Bihuria, is also filed in the court record, which is reproduced as herein below, Lordship. Reference number so-and-so dated at Bihuria SO, Sub-Post Office, dated 2/3/19. Sub-disposal of registered letter number so-and-so dated 14/8/18. Madam, subject cited above that as per your office record, the registered letter number so-and-so addressed to branch manager, Oriental Insurance Company Limited, Bihuria, was delivered to the addressee on 24/8/18. This is the another certificate issued by the Sub-Postmaster, Bihuria. Lordship, despite duly service of notice, both the insurer noticee failed to appear before the tribunal or engage any counsel to represent the appellant. Under the circumstances, the learned member by order dated 11/3/19 allowed to proceed the ex parte against the insurer. There is no error committed by the tribunal at all, Lordship. When, despite service of notice, when the appellant was not appeared before the court, they have not filed written statement, that this is the stage of the tribunal to pass the appropriate order on the basis of the evidence available before him. Lordship, I'd like to refer my gist of argument, page 8. In ground number C of the memo, their allegation is that the appellant is not employed as a regular or pro forma opposite party. Their allegation. The Act does not, this has already discussed before your Lordship. In ground number D, Lordship, page number 9, that has also been already discussed before your Lordship.
The written statement and all.
Yes, because if the written statement they are tried to file, if it is rejected, there might be some order of the tribunal. If not, what action has been taken by them against the action of the tribunal? Nothing. Now it is only submission is only to hush up their lethargy. They have filed the appeal before your Lordship. Lordship, ground number E, F, G, and H. Allegation is disabled, however, no loss of income, no doctor examined, bill voucher not scrutinized, and future medical expenditures illegal. That is their allegation. Under order of the tribunal, by constituting a medical board, the injured claimant was re-examined, who, after thorough investigation, assessed the injury of the claimant at 50 to 60%, Exhibit P17. However, the tribunal considered only 55% disability for assessment of compensation. The disability certificate issued by the board is a public document and no need to be proved by calling the doctor. Lordship, though the medical board assessed under order of the court, medical board re-examined the claimant and assessed that the disability of the permanent disability of the claimant is 50 to 60%. However, tribunal only considered 50% disability. Lordship, the Oriental Insurance Company Limited versus Surendra Omaro and another 2007 3 TAC 4011 is a divisional bench judgment, para 4, Lordship. Yes.
No,
Para 4.
actually, regarding this in Raj Kumar versus Ajay Kumar also,
Yes,
all
Lordship.
this was discussed. And then the Supreme Court said that if it is not contested, if the disability certificate is not contested,
Yes, Lordship.
then it is open to the tribunal to take the certificate as evidence.
Yes, Lordship.
But if it is contested, then doctor has to be examined.
Yes, it is not contested. Otherwise,
So,
also,
in this
when a
case, it was
certificate
not
issued by a
contested.
medical board, it is a public document. No need to be examined by the doctor. It's a public document, Lordship, which may be clarified from this judgment. 2007 3 TAC 40 division bench.
No, but after that, Ajay Kumar is 2011, I think. Ajay Kumar versus Raj Kumar is
Yes,
2011.
Lordship, this judgment
No.
is very relevant.
If it is contested,
Yes, Lordship.
then in that case, the doctor has to be examined.
Even then, if there is no such,
But in this
assuming
case,
that
it was not
doctor was
contested.
contested, but there is no such objection in the court below for regarding the examination of doctor and the medical document. In such a circumstances, doctor is not required to be examined, Lordship. Lordship, in this judgment, para 4, according to us, para 4, Lordship, according to us, although the judgment of the Rajasthan High Court, Rajasthan State Transport Corporation and another Supra in a single bench judgment which only have persuasive value, but while going through para 7 of it, we find judgment of the Supreme Court in case of M.M. Rajappa versus Molhaja Ura Bajappa, AIR 1983, Supreme Court 1633, and also Pandit Praman Katara versus Union of India and others, 1989, Volume 1, SLVR 137, quoted where it was categorically held as per Section 74 and 77 of the Evidence Act that the documents forming act or records of the acts of public officers are public documents. Contents of public documents may be proved by producing their certified true copies via Section 77 of the Evidence Act. It was further held that if a document is a certified copy of public documents, it need not be proved by calling a witness. In the later judgment, Supreme Court discouraged necessity of calling the doctor as witness unnecessarily by observing the following, Lordship. We also hope and trust that our law court will not summon a medical professional to give evidence unless the evidence is necessary, and even men in this profession are not made to wait and waste time unnecessarily, and it is known that our law court always have respect for the men in the medical profession, and they are called to give evidence when necessary, and attempts are made so that they may not have to wait for a long. We have no hesitation in saying that it is expected of the member of the legal profession, which is the other honorable profession, to honor the person in the medical profession and see that they are not called to give evidence so long as it is not necessary. It is also expected that when the facts are so clear, it is expected that unnecessary harassment of the member of the medical profession, either by way of request or by adjournment or by cross-examination, should be avoided, so that the apprehension that the men in the medical profession have, which prevent them from discharging their duty to a suffering person who need their assistance at most, is removed, and citizens needing the assistance of a man in the medical profession received. Therefore, we do not find any cognate reason not to accept the disability certificate issued by a term of expert. So far, in the second point, in respect of assessment of compensation and suffering as per Section 163A is concerned, we find that application is made under Section 166 of the Act. Therefore, such principle under the Schedule 2 cannot be applicable in the present case. In R.D. Ruhatangi versus MS Press Control of India versus Private Limited, 1995, 1 TAC 556 Supreme Court, the Supreme Court also held, although the exceptional circumstances that in the case of pain, suffering, and loss of amenities of life, 100% compensation can be awarded. Therefore, we do not find any cognate reason to interfere in the appeal wherein 50% disability has been ascertained by the court below in the fact and circumstances of the case, Lordship. The Managing Director, Northeast Karnataka Road Transport Corporation versus P. Prabhakar and others, 2004 1 TAC 590 Karnataka in Para 7, Lordship.
See, Mr. Sharma,
Lordship.
This is Allahabad High Court,
Lordship.
but you see this Para 18 and 19 of Rajkumar versus Ajay Kumar.
Lordship.
So this will overrule all this. In Rajkumar, it said that where the disability certificate is given by duly constituted medical board,
Lordship,
they may be accepted subject to evidence regarding the genuineness of such certificate.
Yes,
so
Lordship.
some evidence has to be adduced regarding the genuineness of that certificate. But in this case, I would not like to go into that because it was not contested.
Lordship.
Okay. Because in Para 23 of the same judgment, Ajay Kumar, it says, fourthly, in cases where certificates are not contested by the respondents, they may be marked by consent, thereby dispensing with oral evidence.
Yes, Lordship.
So in this case, we
That
need
is not applicable in this case,
Yes,
Lordship.
that's why we need not
Yes,
go into
here
all
only
that.
question is whether their appeal is maintainable herein or
That's
not.
why, the
Yes,
maintainability is the main issue here.
That is the main issue. And whether,
And if this court finds that it is not maintainable, then you
Lordship.
don't have to go into all the other,
Lordship.
the other.
otherwise also
grounds.
assuming that even if they file any petition before this honorable court under section 170 of the Motor Vehicle Act, if this honorable court allowed their petition, then they may have right to contest the claim on all grounds. That is also not before this honorable court. That is absolutely silent. Nothing has been done. The WS return statement also not filed in the court below.
Yes, I found from the order
Yes.
sheet.
Yes,
that,
Lordship.
nothing.
Everything is there, Lordship. So, Lordship, it is
No
a fit
mention
case.
was even made to allow to file the written statement. Nothing is there because if at all someone had appeared and prayed for admission of the written statement, it will be recorded here. The court records are all here. There's nothing. There's nothing.
Your Lordship, maybe.
And even if it was rejected, you could have approached the tribunal for against that rejection also, or you could have. So many remedies are there. Like that, none of the remedies have been availed. The notice, regarding the notice, there are clear clarifications from the postmaster that it has been delivered. And under Order 9, Rule 13 CPC also, they could have approached the tribunal.
Yes, Lordship.
That also was not done.
Nothing has been done. Now it is comes for appeal, which is not maintainable at all in the eye of law, Lordship. Lordship, in this case, the insurer has deposited 50% of the awarded amount on earlier occasion. That has been allowed to withdraw by this honorable court.
Okay,
even.
okay. How much? 30%?
30%, Lordship, yes.
30% deposited and withdrawn.
Yes, Lordship. That is rupees 19 lakhs 49,364.
19 lakhs
19 lakhs 49,000 364.
64.
I referred this in my gist of argument, page 3. In para 3.
Para 3, okay. Okay, we'll dismiss the appeal, okay? Yes.
25,000 statutory fee to be withdrawn by us, Your Lordship.
Yes, yes, of course, that can be refunded. 25,000.
Lordship, my humble submission.
Yes.
That is the security deposit.
The security
If they
deposit.
succeed in the appeal, then they are supposed to get back. But when they lost their appeal, they are not liable, entitled to get back the amount. That has to be adjusted.
Adjusted against the award.
Awarded amount, Lordship. And if this honorable court allowed the appeal, dismiss the appeal, and may kindly pass an order allowing the claimant to withdraw the rupees 25,000 rupees from this honorable court.
Yes, yes.
Yes, Lordship.
Yes. I heard learned counsel for the appellant, Ms. Kim Penyu. I also heard Mr. B.N. Sharma for the claimant respondent. I'll dispose in the chamber. This one to already have. This Ajay Kumar, Raj Kumar, I have. This one also. This one also. Only this Sheila. one I need.